Welcome to the Lawyering Peace interview series, where we explore the art of diplomacy and the legal frameworks that underpin the peace process. You're listening to our special series focused on peace negotiations, peace building, and the ongoing humanitarian challenges in Ukraine. Join us as we hear from prominent figures who are shaping policy and delivering protection on the ground during one of the most complex humanitarian crises of our time. I'm your host, Dr. Paul Williams, the founder and the president of the Public International Law and Policy Group and the Rebecca Grazier Professor of Law and International Relations at American University. Now, today's episode focuses on one of the clearest and most thoroughly documented cases of international wrongdoing arising from Russia's war of aggression against Ukraine: the downing of Malaysia Air Flight MH-17 on July 17th, 2014. The destruction of MH-17 was not an accident of war. It was the killing of 298 civilians as a direct consequence of the Russian state's military involvement in eastern Ukraine. More than a decade later, the MH-17 case stands as a landmark for individual criminal responsibility, state responsibility, and the rights of victims, and as a test of whether international law can meaningfully respond to aggression by a permanent member of the United Nations Security Council. I'm honored today to welcome Dr. Marieke de Hoon, an international criminal law expert who has worked extensively on the MH-17 case and has been closely engaged with its legal, institutional, and human dimensions. Welcome to the program, Marieke.
Thank you, Paul.
Most members of our audience, our listeners, know Marieke and her background well, since she's constantly on Dutch and international television and in the print media as well. But let me share a couple of paragraphs of her bio for you. She is a professor of international criminal justice at the University of Amsterdam and the director of the Netherlands office of the Public International Law and Policy Group. Her work sits at the intersection of international criminal law, state responsibility, and victims' rights. She has been directly involved in legal analysis and advisory work related to the MH-17 case and has worked closely with practitioners, institutions, and most importantly, the families seeking justice for victims. Marieke and I have been friends for over 20 years, so I'm really looking forward to this conversation. Marieke, let's kick it off. Before we turn to MH-17, could you start by telling us about your professional path? What drew you to international criminal law, and how did you become involved in the MH-17 case?
That's a great question to start with, because that actually was due to you and Michael Sharp 20 years ago. I was a law student, after I studied political science, and Michael Sharp and Leila Sadat were organizing a summer program in the Netherlands at my Utrecht University. And I got to organize it and then spend the whole summer with Michael Sharp and with yourself, who were constantly talking about international criminal justice. And after that, I joined you in DC at the main office of PILPG for half a year to work there. And I got completely addicted to international law, international criminal law, and the rest is history. And then with MH17, actually, you're also to blame, so to speak. Just after a couple of days after 17 July 2014, when MH17 was shot down, our Dutch Parliament reached out to you, to PILPG, to ask PILPG's legal advice. And then you referred them to me, to the Dutch office. And this is how I and Brianne McGonigal-Ley and Julie Fraser got involved in advising Parliament. And I testified a few times in the Dutch Parliament on the legal avenues and ongoing development. And then since the next of kin of MH17, they also reached out to me regularly for explanations and trying to understand how the legal proceedings were ongoing. And as a scholar, I also decided that I needed to follow it from a scholarly perspective and publish about it. And so I published a few scholarly and non-scholarly articles over the years, and also now, almost 12 years later, looking back, trying to analyze what kind of justice we've seen over these last 12 years and in the years that will still be unfolding.
It's always exciting to have these conversations with colleagues and friends who we've known each other for over 20 years because it's an amazing reminder of the arc and that interplay of influence that we have on each other's lives. From a legal perspective, why was the downing of Malaysian Airlines flight MH17 in 2014 immediately understood as more than a tragic aviation incident and instead understood as a serious international crime requiring accountability?
Yeah, I think the most important part of that is that Russia was on Ukrainian territory and denying it. And so thereby was committing aggression and being involved in Ukrainian domestic affairs or violations of international law. And MH17 demonstrated that. It was, and this is also what the court cases later demonstrated, that Russia was actively fighting in that spring of 2014 on the territory of Ukraine, was heavily involved with what they called separatists in trying to get eastern Ukraine to become part of Russia, and was fighting on the territory of Ukraine, constantly going in and out of the territory with artillery and also with a book missile that eventually shot down MH17. So that is part of it. And the other part is that Russia then also denied it actively and made MH17 also part of this huge disinformation war that also the Russia Ukraine conflict is, denying that they were involved and denying that they were on Ukrainian territory, and then also pointing to Ukraine, that it would be Ukraine that shot down MH17. And so the Netherlands was also there standing, okay, now what do we do in this situation? And therefore different than any other crash where, accidents can happen. What usually happens is that then states go behind the scenes and they negotiate and they come to an agreement, ex gratia often, and then settle that and move on. And because of Russia's attitudes in this situation, that was not an option.
And so, as a consequence, the Dutch pursued a number of, and the families pursued a number of legal mechanisms in order to attach accountability to Russia, the Russian state, individuals. And there's been multiple forums over the last decade. There's been a joint investigation team, a Dutch criminal case, and interstate proceedings. How have these collectively constructed accountability for the downing of MH17?
Yeah, so immediately after investigation started and this joint investigation team was formed with the Netherlands as the country where the plane started, Ukraine where the plane was downed, and Malaysia where the plane was moving towards, and also Australia and Belgium, with countries with a lot of deceased on the plane. And they cooperated to investigate, and these investigations then sourced multiple legal cases, procedures that each sort of involved the same fact pattern, but using different legal fields, also for different rationales. So there were criminal proceedings against individual combatants for their personal individual involvement. And there were state proceedings at the European Court of Human Rights for what obligations Russia owed to individuals, to humans, because they were they had effective control over the territory and therefore were obliged to respect the European Convention of Human Rights, and also with the International Civil Aviation Organization, ICAO. That is a civil aviation law. So also the Netherlands and Australia submitted to the ICAO that civil aviation law requires Russia to not just shoot in the air these missiles to safeguard the civil aviation, of course, and also that they were under an obligation to investigate, which they failed to do. And so there were a lot of these different proceedings based on the same kind of facts, but all building up this strong fact pattern that Russia was responsible for downing MH17.
Marika, let's dive deeply into one of those cases. And this is the domestic prosecutions in the Dutch court. So in 2022, the district court in The Hague delivered criminal convictions of individuals related to the downing of MH17. What were the most important legal findings of this decision, particularly in relation to responsibility and the role of the Russian state?
Yeah, pretty much there was quite an amazing amount of evidence, also because the Ukrainian intelligence actually had a lot of recorded conversations from a lot of these commanders involved. And so they could sketch quite an interesting and impressive account of what really happened. And what happened was This is spring 2014. Russia's fighting, as I just said, on Ukrainian territory. Ukraine is defending its territory and is quite effective then in June, July from the air with their air force. And so you hear on recorded telephone conversations the Russian commanders asking the Kremlin for larger, higher ranking anti aircraft missile. So a book teller, they're asking. And so it comes. And then to try and fight back this strategic location, they drive in this book teller, get it to a certain position on an agricultural field, have no radar equipment, and so therefore are pretty blind in shooting it up in the air, take no effort to adhere to the principle of distinction that we know from international humanitarian law that you need to make before you launch. You need to assess whether the target you're aiming at is actually civilian or military. And if it's civilian, you cannot shoot. They did none of that because they had no radar, but also they didn't even use a simple iPhone, which, shows all civil aviation flying right over there. And so they just launched it in the air, shot down MH17, and then you see that they did everything to try and hide the evidence, get the book teller back to Russian territory, and also in the months and years after, fabricate evidence. And so legally, what the court said, what the criminal court said, and which is a little strange in the sense, they said a lot of things about Russia, and strange in the sense that criminal law is usually against, or it is against individuals. So it's quite rare to see such a huge part of the judgment discussing the actual involvement of Russia. And so what it did is describe minutiously the effective control, and this is also how they legally qualified it, of Russia over the Donbass by putting their own people in leadership positions, by being in constant contact, by providing military support, intelligence support, all sorts of other support, anything they needed, and also in coordinating their fighting with the Russian armed forces and the pro-Russian militia forces within the Donbass. And for the three commanders, so there were three commanders that actually, and this is also important, it was an in absentia trial, which is very common in the Netherlands criminal procedure, where our understanding of Dutch criminal law is that the suspects, they have the right to attend their trial, but they do not have the right to block their trial. So they're invited, and if the court and the prosecution establish that the suspects know about their trial, but choose themselves not to attend, the trial can go on. And of course, with a lot of procedural safeguards. And if they would then later on, they have a right to appeal and all sorts of things. It's also the European Court of Human Rights also has approved this under particular safeguards. And so this was also an in absentia trial. Three commanders stood trial, forced commanders to trial. One was acquitted by lack of evidence of his particular role, and three others were sentenced to life imprisonment. And what's the in absentia, therefore, they're at large, but still, the judgment is out there. And what the court said was that these three individuals, including also Girkin, who was then the Minister of Defense of the Donbass, that they were all so involved that they were co-perpetrators with the crew of the book teller, so the missile system that probably had Russian military in it. It's very hard to imagine that it would be others, non-Russian military, but they are unknown. And so if they would be caught, the crew would also be found guilty of murder and downing a plane, but they're not found. And what the court said was these three commanders worked so closely with them in getting the book there, launching it, and getting the evidence away that they are also co-perpetrators and therefore sentenced to lifelong sentence. What's also relevant is that the court took quite some effort in discussing their potential immunity claims because of the question, because it was quite clear how closely they were related to Russia and that Russia had effective control. So then the court, even though it was in absentia, they themselves wanted to really see whether there couldn't have been an immunity claim. And so they said no, because combatant immunity comes from a combatant privilege, saying that in an armed conflict, those combatants that fight in armed conflict have the privilege to do things that we ordinary citizens wouldn't. They can kill lawfully, if of course adhering to international humanitarian law, but only those that are actually under a certain privilege. So only those that are part of the armed forces, and in this case, of Russia. And so the court said Russia denies that they have them there. And these people say that they're volunteers. They deny to be connected to Russia. And so the court said you can't just claim that you then would have the immunity and therefore dismissed the immunity. And on that path, they also discussed, which I think is also relevant, the mistake of fact scenario, because it's quite clear that, or the most obvious scenario is that they thought that they were shooting at Ukrainian military aircraft. And so the court also discussed this, that this is the most likely scenario. And so then under IHL, the question would be like, is this then a principle of distinction violation? And the European Court of Human Rights also later said, yes, that is a violation of international humanitarian law. But the Dutch court didn't go that way. They looked at murder and downing a plane, because this is what the prosecution had asked them, common crimes. And so where they say is if you are not the combatant, if you do not have combatant privilege, you are not allowed to shoot down any plane. You and I also wouldn't be. And so any plane that's in the air would have people on board that would be then killed and therefore murdered. And so they said, we do not even need to know whether they tried to, whether it was a mistake or what may. The fact is that it's proven that they premeditatedly, intentionally shot down this plane. It had people in it. So it's downing a plane, murder, simple. And then the final thing that's really important, what the court said and really established, and the European Court of Human Rights did that as well, is to say, to really put an effort into saying, because it was also constantly communicating to the Ukrainians in recognizing, in saying that what the Ukrainians had been saying all along since 2014 was indeed true, that Russia was on their territory. They also made quite a big point of how requests for legal assistance from the Dutch prosecution to the Russians were responded with falsifications, of false evidence, constructed, malfunction, fabricated evidence, which of course, on the one hand, in current situation, what else do you expect? On the other hand, quite audacious to have that in a court of law.
The Russians have been fairly audacious, at least for the last decade, vis-a-vis Ukraine. So no real surprise there. Let me pivot a little bit now.
No, no surprise there, but it's also good that it's on the record. And so the court, by discussing it, the court really was trying to also put that down on paper, also for the history books in the future.
Yeah. It sounds like the Dutch domestic court did a phenomenal job of, as you say, putting down the facts for the history books for the future. They took the murder case for the downing of MH17 and used it to fully map out Russia's culpability, the commander's culpability, and then the malfeasance and misfeasance of Russia through its effort to shape on one hand saying, look, we're not responsible for this. And on the other hand, making up evidence, creating evidence to try to dissuade the court from prosecuting or finding these
And
individuals
pointing to
guilty.
Ukraine all the time, I think it was also quite important that they kept on trying to make this argument, or at least create mist, that it was Ukraine that had shot down MH17, which the court really clearly established was not the case.
There had been so much success in the Balkans of we're not sure, each party's shelling itself. That narrative worked so well there. The Russians tried it out, and they're doing it now in the negotiations, which is a whole different topic you and I could get into, but trying to shift the blame to Ukraine, to the victim of
And
Russia.
it was also successful because remember 2014, this was also the time when Crimea was annexed. And it took a long time. It also took the Dutch a couple of years after MH17 to be willing to actually stand up, straighten the back, and fight this in courts of law. And part of that was this effective strategy of disinformation in trying to create this myth that it was quite unknown and wasn't it really self-determination, legitimized. And so it's been quite effective. And it took us many years, not you, and I think we were both quite clearly understanding of what was going on, but it took my government quite a long time before they were willing to say, you know what, this is actually, we shouldn't trust Putin. And actually, we now see what is happening and we need to do something.
Oh, this is, and you and I have talked about this quite extensively. This is one of those values of criminal proceedings, be they domestic or international. They call it as it is. The courts, tribunals are finders of fact, finders of liability and culpability, which is antithetical to the approach of most diplomats and certainly the approach of most countries engaged in these types of conflicts. This
Yeah, and this was also interesting because indeed at first there were these criminal proceedings, and I think they were very sensitive, diplomatically sensitive, but not as diplomatically hot as the next steps that followed. Because during those years that criminal prosecutions were being prepared, there was also this discussion of state responsibility. Shouldn't the Dutch and Australia and other parties, because the Dutch tried to get allies with that, shouldn't they actually go to the European Court of Human Rights to hold Russia as the state accountable? And this was at first quite sensitive. We have a lot of trade relations with the Russians. We had at least. Unfortunately, I think we still have, but definitely in those years, was part of the equation. And eventually, the Dutch and the Australians, the Dutch went to the European Court of Human Rights and also with the Australians to the International Civil Aviation Organization.
Marika, can you unpack both of those initiatives for us a little bit? The European Court of Human Rights and the International Civil Aviation Organization, ICAO, both in terms of the politics of deciding to take a case to both of those places to establish Russian state responsibility, and then also how the cases in those two different venues played out.
Yeah, the politics was, as I just said, it was really felt in the Netherlands. Are you gutsy enough to stand up against Russia? And I think a lot of the conversation since has been exactly the same. Like when Ukraine had its full-fledged invasion, the conversation still is, to what extent are we willing and daring to actually resist rather than actually help Ukraine send this off? And so that those similar deliberations were going on. And I think the very active victim population of the next of kin of MH17 was very helpful in influencing this. But also the response of Putin and Russia, because it was constantly with all these denial and pointing to Ukraine and creating false evidence. It was also tempting the Netherlands, or that's not the right word, but it was pushing the Netherlands into this. The Netherlands saying that they're the capital of justice. We've got all of these institutions in The Hague, and then we are being toyed around, lied to blatantly by Russia. And then what do we do with the international legal order? So it also became just embarrassing. And at some point, therefore, the push came to, okay, let's submit this as an interstate application to the European Court of Human Rights, alongside many applications that the next of kin had already submitted. And this was also quite relevant because the next of kin had submitted their applications, but they were not privy to all that sensitive information, all the intelligence that the joint investigation team had gathered. And by this interstate application of the Netherlands, all that information, all that evidence could be shared with the European Court of Human Rights. And what was also relevant there for the bigger picture of Ukraine is that by then joining the cases of the Netherlands versus Russia on MH17 with the other Ukrainian cases on Eastern Ukraine, they could also use all that joint investigation team evidence in all these other cases related to Eastern Ukraine. And so they came one big sort of joint submission, then three submissions. Later on, they added after 2022, after the invasion, a whole set of other violations, but back then alleged violations. But since 9 July 2025, they were found as violations by the Grand Chamber of the European Court of Human Rights. And so this became a massive case that the European Court of Human Rights in its judgment also said that the invasion of Ukraine, the invasion by Russia in Ukraine also is a watershed moment in the history of the Council of Europe that the European Court of Human Rights is part of. And so contesting all these relations that they were really also communicating in that judgment on how to understand these human rights violations in this shifting world order. And so they did that with a gigantic judgment with unprecedented amount of violations across the board in all of these submissions, including MH17. And so what they again said, they very much reiterated what the Dutch criminal court had said in terms of effective control. But of course, for the Strasbourg court, that is really their privy. And this is exactly the role of Russia in Eastern Ukraine, was exactly what was the subject of their investigation, and then to what extent these violations or these obligations were violated. And so that occurred. So the European Court of Human Rights said, yes, Russia was heavily involved and was responsible and has violated a whole set of norms, right to life, torture or inhuman, cruel behavior, but also in terms of the indoctrination of the children that are in occupied territories, torture of detainees, killings, executions of military and civilians, and many more violations. And also found that Russia had failed to investigate all of these violations, but also with MH17, failed to prevent it, failed to violate, failed to investigate, and also undermined the joint investigation team and tried to sabotage that investigation. And so similarly, so we had that massive judgment in July, and just 2 weeks before then, the International Civil Aviation Organization, ICAO, also came with its decision, so a decision by the Council of the ICAO, and found along the same lines. So under the Chicago Convention of Civil Aviation, Article 3 bis says that a state is not allowed to shoot down another civil aviation, quite obviously, and found that this is exactly what Russia had done and also failed to investigate and so forth. Their decision isn't as the European Court of Human Rights is massive. The decisions by the ICAO are very short, but so there's not a lot motivation behind it, but a very clear decision by the ICAO. And this is separate in the sense it's all the same facts, but what it does is also say that it is not just an obligation due to humans, human rights, and of course their countries that protect them, but that it's also an attack on civil aviation and international order. But this ICAO decision is appealed against by Russia itself. So Russia, of course, the decision was against Russia. So in that sense, that isn't so surprising that they didn't agree with it. But I think it was for many people also unexpected, because you would also expect Russia to not want to rub in a stain. One says has been not participating, not responding so much, a little bit objections, but a lot of people just expected this to go. But now they appealed at the International Court of Justice in The Hague, the Peace Palace. And so what now will come is another at least 2 years, I think, of proceedings, of submissions, written submissions, perhaps then oral submissions on whether the ICAO has decided this case in the right way. And so from case law, there's very little. The ICAO, and that's also quite interesting, the ICAO has actually hardly ever been used, also because states usually just go behind the scenes, negotiate, come up with a solution, communicate parts of that or all of it or none of it, but at least they sort it out. And so very rarely is the ICAO used as a court, as an arbitration or what may. And now they did, and only back in the 70s with Pakistan and India, there was one other example where someone went to the International Court of Justice that also quickly dismissed it. And so we have very little precedent to know what the International Court of Justice is going to do. But I expect that the International Court of Justice is going to probably say something down the terms of the ICAO did fine, and we don't want to get into it in too many details. But this is pure speculation. We'll have to see, but we'll have to wait for another couple of years, because that's what the ICJ takes.
Marieke, it's interesting that this case seems to continue. It has 9 lives: the joint investigation, domestic, human rights,
Yes.
ICAO, now National Court of Justice.
And maybe on that, because another thing that isn't finished yet is also with the European Court of Human Rights with the compensation mechanisms. And for the compensation, they said with MH17, they said, oh, there's also this ICAO proceedings that the ICAO decided that Russia and the Netherlands need to discuss the compensation. So let's wait what happens there. And also the next of kin have their individual applications. But a very interesting development there as well is that in the other Ukrainian submissions, part of that case, so with all the violations of Russia in Ukraine separate from MH17, the courts, the European Court of Human Rights said, let's look at all of these developments around the Register for Damages and the Claims Commission that is now being set up to try and offer settlements, compensation for the damage that Ukrainians have done. And so they've said, let's wait and see, and we adjourn the compensation part until we know more of those developments and then take it up. So also that part, the compensation part, or just satisfaction, as the European Court of Human Rights calls it, still will have some follow-up.
And are they seeking to access the frozen assets? There's a huge conversation right now in Europe about the frozen assets and using those for reparations. Is MH17 tied into that?
No, so MH17 is not. So with MH17, the court says, let's wait until what the ICAO has ordered Russia and Russia and the Netherlands and Australia to negotiate, which isn't happening. But at least they say, let's see what happens there. Let's see what happens with the next of kin. And so let's see whether the compensation will be settled. And maybe at some point, hopefully, I would expect they will pick it up. But from the rest of the Ukrainian applications, indeed, they're looking at these very interesting novel developments that is also occurring under the Council of Europe, which is also quite an interesting thing, right? The Council of Europe that wasn't so exciting in the last couple of decades. But now, of course, the European Court of Human Rights is part, but also this aggression tribunal, and now with the Register of Damages and the new Claims Commission, and all these discussions of can we expropriate the Russian frozen assets to pay for all of these damages that is being done and all the compensation that is due, that is owed to Ukraine, obviously. But this is quite an interesting or complicated conversation because, on the one hand, it's quite clear that Russia is doing all the violations. And also because now we have the European Court of Human Rights judgment, we already had the Dutch judgment and so forth. On the other hand, we also, especially the Council of Europe, being like this organization of rule of law and democracy, is very careful in setting a precedent that without a very clear legal title, you can expropriate assets elsewhere. Because if you do it, you're also telling the rest of the world that is fine. That is the new international rule. And there were a lot of discussion because it's a very hard dilemma. On the one hand, it's so obvious that Russia is responsible and there are legal judgments. On the other hand, you do not want to create that precedent and therefore throw away exactly what you're trying to do, setting this international rule of law and trying to defend the rules-based international order. And so there were a lot of discussions because in the past already what had happened is that, or currently, is that interest from these frozen assets, they're already used to give payments to Ukraine. And so now the question was, will we also take the rest? And the decision has been not yet, at least. So the decision has been, we don't dare to do that. And we can do it in a different way on the basis of loans together. They're Euro bonds, but we can't call them that because they're very political.
Politics in Europe? I'm shocked. So really,
Well, we can turn this around, Paul. We can talk about American politics if we want.
that'll be on our next episode. But we have a number of non lawyers, a vast number of non lawyers among our thousands of listeners. And I have to imagine they're thinking, wow, I hadn't realized there were so many legal venues
Yeah,
and
go
so much
study law. It's the best.
you should all go to law school. For our non lawyers, can you walk through a little bit about how this complex mosaic of laws, rules, courts, mechanisms, how does this complex mosaic function when you have a state that is accused of wrongdoing, committing this atrocity, shooting down a civilian airliner, killing almost 300 people? And then the state is both involved in ongoing war of aggression, but also refuses to cooperate. Give us a little context for
Yeah.
that.
The $1 million question. This is, of course, the very difficulty of this rules-based international legal order because there are so very little ways to force a state, particularly a militarily mighty state, and particularly one that has a veto power in the UN Security Council. Because pretty much what international law is based on, in principle, is consent. And so it's very hard to get to go to court against one another state or to force him in other ways. You don't have a police power. Usually you would need the consent of both parties. So also the one you're accusing of violating law to go to the International Court of Justice or other platforms. And so that very rarely happens. And the idea was that all states would enforce international law because that's another thing I get annoyed with. You wear very often, international law is no law because there's no enforcement. No, there's clear enforcement. But the idea was that at least 193 or a couple of more enforcement mechanisms exist. Namely, states have agreed when establishing this international legal order, when establishing the United Nations, that they would enforce international law. And they failed to do that. That is the problem. So it's a problem of lacking political will in putting diplomatic pressure, putting then sanctions, putting all sorts of other pressure, but also dragging other states then to court when you can. And I think that is quite an interesting development of late, of the last couple of years, decennia, where you do see more and more states, also from the global south, going to court. And so a lot of things is, of course, like negative, and we see so many developments now in the world that are very scary. But we also see quite a lot of states with unprecedented amounts that have supported the referral of South Africa to South Africa versus Israel to the International Court of Justice, but also the Gambia against Myanmar case that is currently this week in the International Court of Justice, referrals also to the International Criminal Court. So there's also a lot of states that are saying, now that it matters so much with the international legal order under such pressure, we need to try and do something. And what then a court can do is, of course, on the one hand, you can be cynical and it's easy to critique and say nothing, right? Like what can they do? They can make a judgment and then Russia invades Ukraine anyway. There's no point. But at the other hand, there is also some value in allowing a court then in a position to explain what the norms are and crystallize, develop those norms, because there are so very few cases. And I think that's also what we saw with MH17. It was a way to give to courts the ability to crystallize number of rules, for instance, with also the European Court of Human Rights, to what extent these human rights obligations, how they fit with an ongoing armed conflict. And how do you match that? And then judges get the opportunity to write out how they see that so that it can be used where it actually matters. Not so much in court, it matters there as well, but very much it matters in all of these state departments, justice departments around the world, where it's the legal advisors, where it's the other civil servants that are advising their state on whether or not to do something. They're the ones reading this judgment, hopefully, and the judges can try and influence them to take turn A rather than turn B.
Marika, one of the other, and you touched on this, and I want to dive into it a little bit more, is that these mechanisms, international law, provide an opportunity for the victims, the survivors, the families of victims to seek justice, to create an accurate historical record, and to experience a cathartic process. I know you've been heavily involved with advising the victims, the next of kin, the families of the victims of MH17. Can you walk us through how those families have influenced the pursuit of justice?
I think that what they did is really also setting a standard and an example for victim communities and for victims around the world. And this is not novel, like also in other situations, accidents or crimes with mass victimization, that victims join together, form a communion, and also stand stronger together. They give comfort to one another, at least, they're not going through things alone. But they also together form a voice. And also, what we just were discussing with the difficulty of the Netherlands to straighten their back and dare to go at it against Russia. The victims were very powerful in that. And I call them indeed victims because legally next of kin are also victims, but they're indeed the next of kin, the relatives of the principal, the direct victims. And so they were on. And so part of that is also that the Dutch state was very open, and also the Australian state and other bereaved nations, they were very open to discussing matters with the next of kin, which I think is also really important for the epistemic value, for recognizing the epistemic value of victims, of having knowledge of what is going on, what happened, and also what they need. And so they were very welcomed to discuss like what it is that the victims actually wanted and needed, and to see to what extent that could be taken into consideration in the decision making, or it was taken into consideration. They were communicated with a lot. Also, before any information came out, the state authorities always really took effort to first inform next of kin. But the next of kin also gave back and pushed back. And when it took quite a long time for the Dutch to really decide on, for instance, state proceedings, it really was the next of kin on the phone with Mark Rutte, the current Secretary General of NATO, but then the Prime Minister of the Netherlands, and in saying, no, we really need this and we really want you to do that. And saying that out loud, and that helped for sure.
So, Marika, let's turn back to the space of lawyers. What precedential value does the MH17 case hold for accountability efforts related to Russia's state aggression against Ukraine more broadly?
We were talking about to just like in a broader sense, like to go to court and to use those avenues, and also to open up that space of the ICAO, that the ICAO is actually also an avenue to use. And I think in legal precedent wise, it's probably the most interesting development aside from all the what happened in Ukraine and by Russia, all those legal developments, which are very important as well. And we touched upon that. But also, there was a specific part of the case that was about the behavior, the attitude of Russia after 17 July 2014. So, of course, most of it was about when you commit the crimes and then also connected to that, whether you investigate and so forth. But there was a separate violation found by the Grand Chamber of the European Court of Human Rights that the attitude towards the next of kin of Russia and by fabricating evidence, but by lying, by denying, by not allowing access to the crime scene. So therefore, next of kin had to see with their own eyes on TV how the crash site was just laying there with their loved ones, having this visual on how they were deteriorating there and not respected, not treated with dignity. And that whole sort of set of behaviors of Russia was also recognized and qualified as a separate Article 3 violation, meaning inhuman behavior or inhuman treatment. And this is, I think, quite striking because up until now, the European Court of Human Rights only recognized that for enforced disappearances. And there's a similar reasoning going. Like with enforced disappearance, yes, you lose your loved one, so Article 2, right to life. But also, every single day, the state that has taken that person in custody and has not given any information on what has happened to that person is deciding every single day into perpetuity that the loved ones do not get the information. And that is recognized already longer by the European Court of Human Rights as additional suffering. And now with this MH17 case, it was expanded to say it's not just with enforced disappearance. If a state actually behaves in this way, not just by non-investigating, because that's part of the Article 2 assessment, but really choosing every day to additionally harm victims, then or next of kin, then we should actually recognize that separately. And so I think that is a really important precedent also in the future of at least European human rights, but these usually have some spin-offs in other human rights systems as well, that it's also the behavior after the events that could cause a separate violation.
You've been so generous with your time. I just have one last question for you. And that is that almost 12 years after the downing of MH17, why does this case still matter today for the international community, both legally and historically?
Yeah, I think that's so important because it's often very tempting to say that it doesn't really matter, right? Like these individuals, like all of these 12 years, and what then is the result? Like the commanders that were found responsible, they're free, they're safe. There's clearly no deterrent effect because Russia, in the midst of this all, invaded Ukraine, is not showing anything of wanting to stop and is blatantly violating the international legal order. But I do think that it's really important. And that also goes in the larger perspective of indeed going to court. And that is that I I think we need to see this a little bit broader than just like these end results. It is also very importantly a recognition of victims, taking them seriously. And this is not just the MH17 next of kin, but also Ukrainians that have been since 2014 saying to the world, but the world wasn't listening, that Russia was fighting on their territory. And so the court cases at least are a contribution to recognizing that truth and recognizing the harm that is done to the MH17 victims and the Ukrainian larger victim population. And another thing is also that very often it's said, oh, these commanders, they probably live like kings, and they might. But at the same time, they have this court record in the sense that the court for years was naming and shaming them, was naming what they have done. It's all detailed in a judgment, and it also hangs above their head. There are international arrest warrants. They cannot travel. I know maybe they don't want to, but etc. But it's still there. And I think that's not unimportant as well, is that they are dependent on the current Russian regime for their safety. The Russian regime can always think of a different balancing of their interests and make different choices. And that also goes in the future if the regime would change, and perhaps also constantly therefore owing favors to those powerful So I think it's not completely nothing as well for the perpetrators. I already mentioned for the victims, it is important, but it's also for the larger picture. We discussed this already in this disinformation war. It is so important that, journalists do amazing work, but what courts have on top of that is really an ability to show in this public arena on the basis of procedures, showing publicly evidence and having procedures that the other side can also really contest it. And there can be experts from all sides being heard about it and all publicly then stated and motivated in a reasoned judgment that has some added value, I think, in the disinformation war we are in. So that is very important right now in the short term, but also in the long term, because it's these judgments that go into the history books of the next generations and the next generations of Ukrainians or Russians and the rest of the world. They're the ones that hopefully can find each other again on a common narrative. And hopefully these judgments can help do that. And I think that the other thing, and that's maybe the larger, if you really zoom out further, is also like the current worries that we are all in the international legal order as such. It is really important when there is so much attacks and fighting, danger, risk to this international legal order that we try to at least uphold norms, that we recognize them, that we state them, that these international courts get to try and develop them where they're underdeveloped. Because we often hear now the international legal order is dead. I don't believe that. What is dead is the political willingness to fight for it. And hopefully there is still, and I do believe that there's plenty of at least smaller and middle-sized states that all have a common existential interest in trying to save the international legal order, but they do have to stick together and they do have to find a common language or refind in this legal language, I think, to be able to say what is right and what is wrong and to try and stick together and create a better world.
Well, Marika, that's a great call to action for not only young professionals that are coming into the field of international law policy, but also senior professionals who are looking at what's happening around the globe at the moment. Marika, it's been a real honor and a privilege to have this conversation with you. You've been so generous with your time. It's been
Right
incredible
back
to
at
watch.
you.
Incredible to watch all the amazing work you've done on MH17. When we first met 20 years ago, you were bright-eyed, bushy-tailed 20 something. And as a faculty member for me now, and as you as well as a faculty member, it's just so amazing and rewarding to see young professionals grow into mid-career professionals. We've worked on over a dozen peace negotiations and transitional justice mechanisms. You've directed the Dutch office of PILPG. We get together every year at the ASP for the International Criminal Court. So it warms my heart to see a young 20 something now be a full professor at the University of Amsterdam and having your own cohort of hundreds of young professionals that you've trained that, as you say, will go on to do amazing things and will.
Well, and on my end, I'm so grateful for all the fun and all the opportunities and all the teachings that you and also Michael Sharp gave me over the years. I couldn't have been where I am now without that support, that mentorship. And I think that's also something to say to all the senior people out there and the junior people. It's a community that we create and that people like you have been very active, you specifically have been very active in creating that. There's another way of trying to uphold this international legal order, trying to stick together. And what I really enjoy also of you and PILPG is the always debating on these really tough topics of international law and politics thereof in this community of the wisest people, the experts of the world, and to sharpen our brains. So thank you so much for creating that collective and letting me play in it.
You and I are blessed with a number of friends and colleagues who want to think about these perplexing issues and conundrums. So, well, for our listeners, this has been another episode of Lawyering Peace as part of our series on justice and accountability for Ukraine. And we look forward to our next conversation with you all. Marika, thank you very much and have a
Thank
great rest of
you.
your day.